Leo tuna furaha sana, kwa mara ya kwanza wanyonge wamepata haki zao, na majaji watatu ambayo wamekalia ile shida ambayo ilitokea kwa mambo ya conservancy, haswa baina ya wananchi na NRT. Ingawa hiyo mambo imeendelea kwa muda mrefu, ingawa wanyonge wamelalamika kwa muda mrefu, leo haki imepatikana na hawa majaji watatu walitoa hukumu ya haki. Tunatoa shukrani kwa National Human Rights Commission ambaye headquarters zao ya Northern Kenya, ambaye headquarters yao ni Wajia. Lawyer Adan Dalacha ametusaidia. Asante pia kwa lawyer yetu kijana mzaliwa hapa anaitwa Abdullahi Halkano Kela, na malawyers yote ambaye walitusaidia kupambana na dhulma. Sisi kama wafugaji, ardhi ndio rasilimali ya kipekee ambaye tuko naye sisi, na ikiwa sisi hatuwezi kulinda, haswa wakati huu kuna community land registration inaendelea, alafu wengine wanataka kupora kutumia kwa njia isiyofaa, basi sisi tutaumia zaidi. Kwa hivyo ndio tumeungana sisi wana harakati wa haki ya kibinadamu wa media wetu wa kinyumbani kama Angavu Radio na sehemu zingine, tumeshughulika sana kuona ya kwamba haki ya umma imepatikana. Hiyo ni sio kusema ya kwamba sisi tunakataa donors ama investors katika ardhi zetu, lakini tumesema NRT wakaa kando kidogo mpaka tupate land registration ambayo katiba sasa imetupa. Kwa hivyo wameshinda kustahimili. Kwa hivyo leo uamuzi ilikuwa ni ya haki, imeturidhisha sisi wananchi. Tumejua kwamba at least kuna haki katika Kenya katika nyanja tofauti. Kwa hivyo tunashukuru nyinyi waandishi habari pia, na sema leo pressure na hiyo sukari yetu yote inashuka.
Thank you so much. Thank you for coming and highlighting the story that we are dealing. We've just come from the 3-judge bench ruling, and our clients and myself are quite happy and welcome that judgment. We think that judgment is quite extensive, and it's very, very well reasoned, and it has offered a lot of guidance and structure on this issue that concern the establishment of conservancies and the issue that's concerning community land rights. I believe for our clients, this has we are welcoming it, and it has very far-reaching ramification in terms of affirming their rights as community members and as members who own the property. They are the ones who should be consulted first, and the court has established a structure of what is supposed to happen if indeed you want to engage the community or you want to utilize the community. Yes, indeed. Before we came, we filed this case in 2021, and it's been quite a journey before we got here. And before a judgment is rendered in a case, according to our constitution, the court usually gives parties an opportunity to speak and try to negotiate and try to solve these issues before, the court can give its judgment. So prior to coming to court, we try to engage officials, and as you've heard from what the judge has said, we try to engage the local authorities, we try to engage the ombudsman, we try to engage the National Land Commission. So we tried so much. We did not just wake up and go to court, and that's why even the court ordered and made a finding that indeed we tried alternative dispute resolutions before coming to court. So coming to court was our last resort. Yes.
And were you confident of now getting these? And why?
Yes.
What made you feel so confident in this case?
I think I was very confident, and what made us confident in this case is the extensive research that we did prior to filing this case. And we thought that there are glaring, constitutional issues surrounding these, issues that brought us to court. And we perused the Constitution and the Community Land Act and noticed that there are so many, violations that the court has just affirmed and agreed with us. So at this point, it's no longer an allegation, but it's a factual finding of court that indeed the members of Merti County, Merti sub-county, were not involved when these conservancies were established. The court has made a finding that there was no public participation. And the court has also made a finding that these conservancies that are operating in these areas are doing so illegally. And the court has also made a finding that even the rangers and arming of rangers is not according to the law. So this is what gave us the confidence to come to court. Before that, we did extensive research and highlighted and appreciated the gaps that we have in terms of utilization of community land for our clients. We did not have an estimated cost because that prayer is unique in nature, because it's very hard to document the exact amount of damages to be sought. And the court, in its wisdom, indicated that this is a matter that affects over 3,000 acres of land and thousands and thousands of people, of community members. So the court made a finding that it was impossible to offer guidance just to a select number of people who approached court, because our clients were 165 petitioners, but they represent the entire of Merti. So the court made a finding that they could not offer damages just to us who came to court, and there was no, structure to indicate that the other community members also will benefit from such damages. And we abide by that. We respect that. Okay. Yes.
And lastly, on the issue of the 14 days sort of stay order, are you satisfied with that? Or?
I'm a bit aggrieved. However, it's okay, because my position is that, and I presented this as much in court, my position is that you cannot suspend rights. And when there is an affirmation by a court of law, and as I said, we are no longer alleging, there is an affirmation that our clients' rights were infringed. So in my reasoning, you cannot stay rights. Because when there is an infringement of rights, then there ought to be an immediate injunction, and there ought to be steps taken to at least make sure that the rights are protected and confirmed. However, it's okay, it's their right, it's within their right, because we've been patient in court since 2021. After 14 days, we'll see what they'll bring to us, and we are also ready to go to the Court of Appeal if we'll be taken there, because we are very confident with our case. And we believe that even going further, the Court of Appeal hopefully will still affirm our position.
And don't you have fears it is going sort of to delay the implementation of these judges?
There is that, but unfortunately, sometimes justice grinds slow, and we've been here since 2021. We can still wait some more, because when on matters of rights, we can't give up, especially for our clients who are indigenous people and very vulnerable people. As long as it will take, we will do what it takes to make sure that we prevent any person who's trying to infringe on their community land rights and all the issues that we presented in court. Yes.
Maybe you didn't share your name?
My name is Innocent Makaka. Yes.
You are
this matter? Yes, Innocent Makaka. I practice in Nairobi, but we've been dealing with this case since initiation. Yes, I also have a lot of colleagues that we deal with. I don't work alone.
Maybe you could mention the other lawyers that you are working with.
The other lawyers, I'm working with Mr. Halkano Abdullahi. He's also a lawyer. I'm working with Mr. Adan Adalacha. He's also a lawyer who is assisting me. And also Mr. Michael Nolan Maliambo is also a lawyer who's assisting us. And several other researchers. Yes.
Yes.
Thank you so much, Mr. Awil. Thank you.